Okay class, good evening. So now, this video, we will tackle for third topic for our final exam. So the topic will be assignment of credit in other incorporeal rights. So let's start. So concept for assignment of credit in other incorporeal rights. So assignment of credits, it is a contract whereby a person or the assignor transfer credit, right, or action against a third person or to another person or the assignee for the consideration which is certain in money or its equivalent. So meaning class, if you have a credit right, let's say for example, you have a receivable with the other person, so you can assign it to other person. So just like in accounting, so assignment of receivables. So in assignment of receivables, 'di ba ang nangyayari sa accounting nyo, when you have a receivables with the individual person or let's say corporation, so you can assign it to a bank. So ngayon, yung bangko magbibigay ng pera. So it's one way to have a cash flow. So let's have an example. D owes C for 5,000. So si D may utang kay C for 5,000. Now, C assign his credit to T for a consideration with notice to D. So here class, si D, he is the assignor. Now, C is the assignor and T is the assignee. So ngayon ang gagawin ni D will make a payment to T. So yun lang yun. Now, what is the nature of assignment of credits and other incorporeal rights? So it partakes of the nature of a contract of sale. Hence, it is perfected at the moment there is a meeting of minds upon credit right, which is the object of the contract, and upon the price. So, according to Article 1475 and as well as in relation to Article 1624, assignment of credit and other incorporeal right class are perfected by mere consent as long as there is a meeting of minds between the two person, so it is a perfect contract. Naintindihan? Just like in a contract of sale. So contract of sale is perfected by mere consent. Forms of assignment of credits. So ano yung mga forms? Number 1, so what are the requirements by the law between the two parties? It may be in any form. It may be oral, written, or partly oral and partly written. So, ibig sabihin class, between the two parties, kay assignee at saka assignor, pwedeng oral, pwedeng nakasulat, or pwedeng oral or written. But to bind a third person, so ang sinasabi ng batas, if it is personal property is involved, it must be in public instrument. So, dapat may notary ng attorney. Next, what if real property is involved? So, dapat it must be in public instrument and at the same time recorded in the registry of property. That is the requirement under the law. So, Article 1625 of the Civil Code. So, ibig sabihin class, dapat naka-notary. Kapag real property, dapat may notary and at the same time, i-record nyo sa registry of deeds. So, next, effect of payment by debtor to creditor. So, what will be the effect before the knowledge of assignment? So, take note class, here, anong magiging epekto kapag si debtor binayaran si creditor? So, there is no there is no assignor assignee here. So, before the knowledge of assignment, so the debtor is released from his obligation if he pays his creditor without his knowledge that his debt has been assigned. So, let's go back to previous. Dito class, what if daw kung binayaran ni D si C? So, yun yung sinasabi. So, si D will, wala na siyang magiging utang. So, yun yung sinasabi sa here, number 1. Take note class ha, hindi alam ni debtor na merong assignment na nangyari. 2. What if after knowledge of the assignment, what if alam ni debtor na merong assignment na nangyari, the debtor is not released from his liability to pay the assignee. So take note class, ang nangyari dito, binayaran ni debtor, binayaran ni D, si C, pero alam niya na merong assignment. So, di ba, supposed to be general rule, D must pay T or the third person or the assignee. So, pero ang nangyari, D pays C. So, D will not be released from liability. It's because dapat here sa number 2, ang babayaran ni debtor is the assignee. Okay, next is, take note class, an assignment does not require the consent of the debtor. So, general rule class, kapag magkakaroon ng assignment of credits, no need to have the consent of the debtor. So, gaya dito sa atin example class, di ba si C, inassign niya yung credit niya kay T. So, ang sinasabi class is, it is not required to get the consent of D para i-assign yung credit ni C. So, yun yung sinasabi sa dito. However, take note class, however, actual notice must be given to him of the assignment so that he could make his payment to the assignee. So, ibig sabihin daw class, gaya dito sa ating example, dapat sabihin ni C kay D na inassign yung credit right ni C kay T para si D magbayad kay T. Naintindihan? So, yun yung sinasabi dito. Notice is, this notice is for of protection in favor of the assignee. So, dapat, kaya nagre-require ang batas na dapat magbigay ng actual notice si assignor kay debtor para for the protection of the assignee. Naintindihan? 'Di ba? Si assignee is siya yung tatanggap ng payment from the debtor. Next, accessory rights included in the assignment. So, ano yung mga included na accessory rights? Number 1, guarantee. Number 2, mortgage. Number 3, pledge. Number 4, preference. So, this inclusion of accessory rights in the assignment is based on the rule that the accessory follows the principal. So, syempre naman, kung saan yung nanay, nandun din yung anak. So, ito yung, hindi ba, let's say for example, kapag mangungutang ka, kung minsan merong naka-mortgage, naintindihan, may naka-collateral. So, mortgage ang tawag doon. So, ibig sabihin, kapag inassign mo yung loan mo or credit right mo sa ibang tao, syempre, yung accessory rights or the mortgage or the collateral is masasama dun sa assignment of credit. Next, however, the parties may stipulate that accessory rights shall be excluded from the assignment. So, general rule daw class, the accessory follows the principal. But, pwedeng may stipulation na yung accessory rights hindi kasali kapag magkakaroon ng assignment of credit. Next, example. So, D obtained a loan from C amounting to 200,000. The loan is secured by a mortgage of this lot. So, ibig sabihin, naka-collateral yung lupa ni D. If C assigns his credit right to X, take note ha, if C assign his credit to X, the mortgage right is also considered assigned. Naintindihan? So, di ba? Sabi dito sa 1537, the mortgage right is also considered assigned. So, unless C and X agree otherwise. So, may stipulation silang dalawa. Sasabihin ni C na, i-assign ko ito, hindi kasali yung collateral. So, yun yung stipulation. Next, warranties of assignor. So, Article 1628. Number 1, the legality and existence of the credit at the time of sale. However, there is no warranty if the credit was sold as doubtful. Example, DOC 10,000. The debt is evidenced by a promissory note. So, this is the principal contract, promissory note. Thereafter, C assigns his credit right to X. If X cannot collect later from D because the note was issued for and for illegal gambling debt, C will be liable to X because he warranted that the credit was legal and he assigned it to X. So this is the example, class. So winawarranty from the time na nag-assign si C kay X, winawarrant niya na merong legality at saka nag-i-exist yung credit. Meron talagang utang si D kay C. So, pero merong exemption. Walang warranty kung yung credit is ibinenta as a doubtful. Doubtful talaga dito, class. Naintindihan? It's because yung it's because yung utang pala is illegal gambling debt. Illegal, oh. So, ang sinasabi ng batas dapat legal. What if X cannot collect from D? So, paano later on hindi makakolekta si X kay D? Because it turned out that the debt had prescribed. C shall be liable to X because he warranted that the credit existed. So, na-prescribe na pala yung utang. Naintindihan? Let's say, for example, utang 10 years nang hindi nababayaran. So, since prescription period, so dapat wala nang right si C na mangolekta kay D. Pero, inassign niya pa rin yung kanyang credit right kay X. So, syempre si X cannot collect kay D. It's because pwedeng erase na defense ni D yung prescription period. So, ngayon, ang mangyayari, ang habulin ni X is si C. C shall be liable to X. Assume that the credit right is in litigation. Here, the credit is doubtful because whether D is liable or not to C depends upon the outcome of the case. Accordingly, if X later on cannot collect from D because the court adjudged him not liable to C, X cannot hold C liable. So, dito, class, what if daw yung utang is litigation? Ibig sabihin, kinasuhan ni si D. So ibig sabihin, kinasuhan ni si D is because para lang magbayad si D. So, pero ang ginawa pa rin ni C is inassign kay X. So, yung credit ngayon is doubtful. Why? Hindi mo alam anong magiging outcome ng kaso. Whether mananalo ba si C or not. Maintindihan? So, accordingly, if X later cannot collect from D, it's because yung court adjudge him. So, ibig sabihin, adjudge him not liable to C, so X cannot hold C liable. Next, as regard to the debtor's solvency, he does not warrant the same, except when there is a stipulation. When the insolvency already prior to the sale and of public knowledge. Example, D obtained a loan of 50,000 from C. Thereafter, C assigned his credit right to X on due date. X demanded payment. C assigned his credit right to X. On due date, X demanded payment from D. But D cannot pay because he is insolvent. Wala nang pera si D. Ngayon, X cannot go after C. Naintindihan? So, syempre, hindi mo pwede, why? Hindi ka pwedeng X cannot go to C para lang maningil ng utang. Naintindihan? Yun yung general rule natin, class, ha? Pero may exemption sa general rule. Ito yon. Liabilities of the assignor when warranties are violated. So, ibig sabihin, nag-violate ng warranty si C. So, kapag nag-violate ng warranty si C, so C is liable to X. Number 1, if he was in good faith, he shall be liable in the following. Number 1, price received. 2, expenses of the contract. And C, other legitimate payments by reason of the assignment as per Article 1628 and 1616. 2. If he was in bad faith, he shall be liable for the following. Number 1, price received. Expenses of the contract. Other legitimate expenses by reason of assignment. And lastly, damages. So, yun yung pinagkaiba, class, ha. Kapag in good faith, walang damage. Kapag in bad faith, meron ng damage. Duration of assignor's warranty of the debtor's solvency of assignor was in good faith.